Hi, everybody. My name is Anthony Kim. I am a partner with Nick Rosado. We are with the firm of Kim and Rosado based in both Los Gatos, California and Walnut Creek, California. Today, we want to talk to you about cannabis companies. Now, cannabis companies, based on where you are, but in our case, California, are legal. So it's legal to both use and sell and distribute. But for federal tax purposes, there's a code provision that's section 280 cap E, which disallows the deduction of what would otherwise be ordinary business expenses from gross income associated with the trafficking of Schedule 1 and 2 substances, such as marijuana. So there is a tension. So California is a state that allows businesses to sell and users to purchase and use. But federal law disallows such deductions. Now, Nick, as an attorney for the IRS, he worked on cases that involved cannabis companies. Nick, can you explain to the viewers of this recording, what was your involvement with the IRS as to cannabis companies?
Sure. Thanks, Tony. So the IRS enforces the tax laws with cannabis companies. As you were saying, cannabis is in a weird place or the industry is in a weird place because it's still illegal for federal purposes, but it's legal for state purposes, use and distribution. And it's still classified as a Schedule 1 drug. Therefore, as you said, 280 cap E of the Internal Revenue Code says you don't get any business deductions for trafficking in any Schedule 1 drugs, and that includes cannabis. So the industry is in a tough place where many business expenses that any other company would be able to get, rent, labor, transportation, any type of ordinary and necessary expenses that a business is going to incur won't be allowed. So these companies, to a great extent, are taxed on gross income. And the IRS heavily enforces this industry because over time, the industry had been taking, or many players in the industry had been ignoring 280 cap E, and the IRS began to heavily enforce that code provision. So because it was a new area of law and developing, I think back when we were in the IRS, Tony, some years ago. So at that time, the IRS developed what was called the marijuana cadre. So that was within the chief counsel's office of the IRS, and attorneys in that cadre were tasked with both advising revenue agents and revenue officers on audits and collection in that space, but also tasked with litigating cases that did go to tax court. So as part of that group, I did both advise our client, the IRS, on these issues, the legal issues that we were facing, and I also litigated cases in the tax court on behalf of the IRS against businesses within the industry that were potentially not complying with 280 cap E.
Now, Nick, you talked about legal issues that you litigated on behalf of the IRS and the U.S. tax court. Not many cases make it to tax court. Most cases get resolved either at exam, or they'll certainly get settled, most of them at appeals, but a lot of cannabis cases went to tax court. What are the issues that you litigated that went all the way to tax court?
Yeah, so I mean, it was, at the time, companies kept attacking 280 cap E in different ways because there had been a number of court decisions already that said, hey, 280 cap E is the law of the land, you have to comply with it, but it's such a harsh provision for these companies that they just kept attacking it. So I think most of the cases that I saw, it did address kind of issues that had been raised and raised again, Some of that was maybe part of the companies, and maybe some of that was poor advice from the people advising these companies about whether to pursue litigation, as it often ended up being costly, and they ended up without any victories. So,
yeah. Now, with respect to, let's say, cases that should not have been taken to litigation, how many of these cannabis cases do you think really revolved around bad records?
it was certainly a lot of these cases. I think in tax court, even through today, it's bad record keeping is certainly a big part of it. But even outside of the bad record keeping, there's just the difficulty of many companies are still just trying to take business deductions and treating them as business deductions. There are different legal theories that you can pursue nowadays. But I think a lot of it is just bad record keeping and kind of legal theories that have already been debunked.
Now, speaking of legal theories, can you explain the difference between cost of goods sold and whether cost of goods sold would be something that a cannabis company can use to reduce their taxable income? So what makes up cost of goods sold, and can a cannabis company use cost of goods sold to reduce their taxable income?
Right. So 280 Cap B disallows business expenses. So those are not cost of goods sold. So there's potentially there is a constitutional issue with the government can't tax someone on gross income. They have to at least allow cost of goods sold. Some courts have said that business expenses, those don't necessarily need to be allowed. It hasn't necessarily been litigated all the way at this point, but because there's a difficult question of what's income, and that's a constitutional question because income can be taxed without direct apportionment. So there's a difficult question of what income is, but I think it's pretty settled that cost of goods sold has to be allowed. And I think that's a constitutional issue. I think a lot of courts have found that to be a constitutional issue. So what cost of goods sold is, on one hand, it's a constitutional issue, but it is defined in the Internal Revenue Code. It depends on what type of business you are. So if you're a producer, you have very expansive cost of goods sold, which would include indirect costs that would generally be otherwise business expenses for most other businesses. If you're a retailer, a distributor, you're in a tougher position where cost of goods sold is really just cost of acquisition. But what cost of acquisition within the Internal Revenue Code, how broad that is, that's something that hasn't really fully been litigated at this point. So that's still a developing area of law because the regulations can be read a little broadly, depending on how you look at it. So that's still a developing issue. And then I think another developing issue is certainly, are those definitions of cost of goods sold correct? Because it's a constitutional issue what cost of goods sold is. And the IRS is certainly, and Congress is saying what it is in the Internal Revenue Code, and the Internal Revenue Service is interpreting that in the Treasury regulations, but that's not necessarily what cost of goods sold are for constitutional purposes, which is still something that's up in the air.
Okay. So if I were to summarize, if cannabis companies have bad records, that's a problem that probably should not be taken to litigation. But even though we have a very broad and specific code section, 280 Cap B, that disallows a deduction for cannabis companies because they're Schedule I substance, it's not a black line as far as 280 Cap B doesn't say, well, you can never go to court. You may have some issues that still warrant some movement by the service and perhaps warrant litigation. Is that fair to say?
Yeah, definitely. So that's definitely fair to say. So sometimes the service may not give you a fair shake on audit, and it doesn't hurt in some situations, depending on how the facts are, um, to seek some maybe a better resolution, either in appeals or in court or both, right? So sometimes you have to go to court to go to appeals, um, so that someone can consider the general risks involved rather than just the black letter law, which is what IRS does on audit. So um, even if you don't have great records, sometimes you can get something if you do appeal it, and if you do approach it the correct way by trying to prove it through circumstantial, trying to prove whatever you're trying, the expenses or the cost of goods sold or whatever you're trying to get expensed through circumstantial methods and things that would tend to indicate that these things were incurred, even if the records aren't great. There are ways of doing it, but you have to be thoughtful about it.
Yeah, yeah. It's a broadening area because more and more states are legalizing cannabis. California, I think, was one of the early states to legalize it. But that said, the federal area has been fairly uniform, with 280 Cap B being on the books of Title 26 for a long time, but there's still litigation. And the advice here is to make sure that taxpayers who are in this space, cannabis companies, make sure you hire the right people, knowledgeable people, and understand which issues can be litigated and which ones should not see a courtroom. All right. Well, thank you for your comments, Nick. I think the audience will appreciate it. Talk to you next time.